Case number 116146, State of Kansas v. Deron King.
If it pleases the court, Michael Highland appearing for the appellant Deron King. I will be requesting 3 minutes, if that's all right, at the end for rebuttal.
3 minutes is granted.
Thank you, Your Honor. This case involves it is a criminal case. It involves one of 3 individuals who were charged and convicted of 1 count of attempted capital murder, 3 counts of aggravated robbery, 2 counts of aggravated battery, 1 count of conspiracy to commit aggravated robbery, and 2 counts of criminal possession of a firearm. My client, Mr. King, was sentenced to a life sentence with a mandatory 25-year sentence and a consecutive 449 months to follow. There are a couple of main issues. I did put the issues that I saw in this case into the brief. I did not try this case. I was only appointed on the brief, and I will not reiterate what was in the brief. I know you've all read that, but the biggest issue, I think, was the prosecutorial error that came about when the prosecutor used words like, "we know," "I submit," "I don't think," "I believe," when she was talking about the evidence in the case. In this particular case, Your Honors, there was a large amount of KSA 6455 evidence admitted by Judge Burdett. This wasn't the only robbery that happened, the one that was detailed here, and the only shooting. There were at least 1 other case in Kansas City, Kansas, and at least 3 cases in Kansas City, Missouri that were given to the jury. They saw witnesses, they saw all kinds of evidence, they saw 3 guns that weren't involved in this case, a lot of clothing and photographs and movies from these different robberies. All that went to the jury, so they had more than just the information in this case on which to try this defendant. Along with the 455 evidence, you had the circumstantial evidence, which is what this case was all about. There was no physical witness identification, no facial features, anything like that. It was all circumstantial based on clothing, tennis shoes, the things that they observed in the movies at these different robberies. What I would submit to you, judges, is that because of the 6455 evidence, which was substantial, and because of the circumstantial evidence, which also there was quite a bit of it, it wasn't just 1 or 2 things, that would have been maybe enough for the prosecutor to leave it alone. I'm not saying that would have been enough for a conviction, but she should have stopped there. Even if she had gone to the jury and maybe once or twice said, "I don't think this," or "I believe this," maybe once or twice wouldn't have been so bad, but I quoted 14 times in my brief in the statements, but actually she did it more than 45 times. What she was commenting on was not all uncontroverted, or controverted, she was commenting on controverted evidence, unsubstantiated evidence, as if it were factual, and it caused the jury to believe that it was factual, is my assertion to you. There was so much of it that the jury just thought, boy, they've got this guy hands down.
Mr. Highland?
Yes, ma'am.
Can you tease that apart a little bit, the numbers of remarks and exactly what their content was? I'm sorry, could you not hear me? Let me speak up again. I'd like to tease apart a little bit the number of times these things were said and what exactly was said, because I don't think they're equivalent to one another.
You mean the 14 times that I put in here?
I think we've counted up 22 I submits, 36 we knows, 2 I believes, 2 I thinks, 1 I don't think.
Okay, well, I'm sure you're accurate on your count.
Okay.
I didn't actually count it.
Let's just assume that's a working number, okay, for purposes of this discussion. How is I submit error? Why isn't it equivalent to the evidence demonstrates?
Okay, I know that I submit is one that prosecutors use, and it's what the Supreme
And
Court
defense lawyers
they should
too.
use.
Yeah, and in fact, I think the defense lawyer did use it in this case.
Yes. And I'm not saying that that was in itself what caused it. It's just it was one of many. That was one of many of the different phrases that she used.
I understand it's one of many phrases, but we're trying to decide what's error here.
I
And I'm
understand.
asking you to talk specifically about I submit. I just don't see what's wrong with that.
Okay.
Is it just the worst use of the word I in front of it? Is any phrase that includes the word I potentially error? Is that your position?
There was one for sure, if I can see it here. At the top of page 10 of my brief, I wrote, I submit to you that the evidence presented to you is sufficient to prove that these two defendants, Dyron King and Cecil Magerson, are guilty beyond a reasonable doubt of the crimes charged. Because of the evidence, she's saying, I submit the evidence to you that causes them to be guilty. It may or may not, it's just evidence, and they're the ones that determine guilt.
Isn't that the whole point of the state's prosecution, to submit the evidence to the jury? Again, I guess I'm just,
Okay,
how
let
is
me go.
that improper?
I understand your question. Let me go one more. On down the page it said, and now this one I think was a leap. And I submit to you that those are the same shoes that have Brendan Foxworthy's blood and the same shoes that have Dyron King's wearer DNA that recovered in his bedroom. So it automatically tells the juror, well, if the police officer's blood is on those shoes and they were found in my client's bedroom with his DNA on it, he obviously is the one who shot the officer. And that
But
may or
isn't
may not
that
be true.
what
In fact,
prosecutors do?
Excuse me?
Isn't that what prosecutors do? They admit evidence
they do.
under the supervision of the court,
Okay, well,
and then they argue at the end, now you've seen all this evidence, here are the different pieces. That adds up to guilt.
I understand.
I just think I submit is different from some of these others.
It is, and
that
I
you've complained
agree with
about.
that. I know that's the one the Supreme Court actually tells prosecutors to use most of the time, and I understand that.
Okay, thank you.
So if you like, I'll go along with the I don't, the I don't think, or the I believe, or the we know. So those I think were ample in themselves.
There were a lot of we knows.
There were. And again, if she had only done it once or twice, it wouldn't have maybe been such a major thing, but it was done so many times that the jury heard it over and
And
over.
just so I understand your position on the we knows, you're not really complaining if they are in fact introducing a reference to evidence that is undisputed.
Well,
Would you
okay.
make that distinction?
Well, it could be, but the very next one after that is, I submit, this is where they were leaping again. We know that Dyron King's DNA is on one of the Easton batting gloves that was recovered in Charles Browser's Lincoln in the driveway of Dyron King's house. So we know that was recovered. And we know, based on what you can see in all the videos and the still photos that have been taken, that those Easton batting gloves are used in every robbery from Don's Liquor all the way to 7-Eleven. We don't know that. Similar gloves or some that look like that, but we don't know if those are the gloves. And
That particular pair is what you're saying.
okay, yes. And she could have at least said, we know that looks just like the pair, but she said those are the gloves that were used in those robberies. We don't know that, and the jury was told that those were the gloves. So those are the problems we have with that, Your Honors. And the
So
only other
just
thing
to-
I have
Counsel, I'm sorry, I just wanted to clarify.
really,
It sounded like you, in your answer to my colleague, you agreed that if the evidence was uncontroverted, the statement we know could be proper. But in any instance in which there was a possibility of a different interpretation of the evidence, saying we know is improper. Have I correctly paraphrased your argument?
probably. I probably wouldn't say set in stone that's correct, but, and I know that some of these, there were some uncontroverted evidence and some was controverted that she was talking about. So give a few, take a few. There were just several that she shouldn't have done it on, is my argument. The other big issue that I have, Your Honors, is, I'll be brief here, the antagonistic defense that was put forth by the co-defendant. There originally were 3 defendants. One of them asked to have his attorney withdrawn, and he was appointed a new attorney, so his case was severed. And these 2 defendants, their attorneys had agreed that we're just going to go and have the prosecutors put on the evidence and prove that our clients are guilty. And that was pretty much how the trial went. It was a 10-day trial, a lot of transcripts, but it was at the closing that the other defendant and his attorney completely deviated and started saying the things that I listed in my brief about how all the evidence points to Mr. King, it's not my client. We know Mr. King did this, there's no evidence against my client. And at that point, my client was no longer only fighting the prosecution, it was fighting the defense, and it should have had a severed trial. I
Mr.
understand.
Highland, yeah, I was just gonna say, why wasn't it incumbent upon defense counsel at that moment to leap from his circle chair and say,
It was.
Your
And the
Honor,
only,
I need a severance now?
Your Honor, I believe it was error on the part of the defense attorney to not do that.
And a waiver, right, by your
She's-
client? A waiver of his right to
I know
sever?
that if you don't bring it up right then, that you lose that argument for appeal. But in this particular instance, I know there are some exceptions. I don't know if this falls within them, but I can tell you that ineffective assistance of counsel is one that this client will raise on a 1507 for sure, because she did not bring up
Are
that
you
issue.
seeking a Van Cleve remand today?
I'm sorry,
Are you seeking a Van Cleve remand today?
if that means you'll allow this to be decided on its merits rather than just dismiss it forthwith, yes. And that's all I have, unless you have any more questions.
Any more questions?
Thank
Thank
you
you,
very much,
counsel.
Your Honors.
May it please the court, Ethan Ziv Sigler from the Wyandotte County District Attorney's Office. I think I'll start with the prosecutorial error analysis. There is, I think the most, probably the one that comes closest to the edge of being prosecutorial error is the comment that, and we know the gloves were used in the robberies. The state would submit that is a very poor way to word that. The prosecutor probably should have prefaced that by saying we know that consistent gloves were used in each of those.
Yeah, it's not just poor, it's wrong,
Um,
right?
I believe, yes. I believe that based on what the court has held, yes, that saying we know they were the same gloves would be error.
So how is it, just move over and talk about reversibility?
I do not believe this comes close to a reversible issue. It is a very minor piece of evidence that in a mountain of evidence against this defendant, including the Deputy Scott Wood's DNA was found inside the chamber of the revolver that was in Deron King's room. The consistency of the pattern of robberies between the 5 robberies, the
Was
other...
that the only article of clothing that was consistent across the entire group? I think it may have been.
It may have been the only one that was consistent across all 5 robberies, but it wasn't the only one that was consistent across multiple robberies, including the robbery of the
Right.
7-Eleven.
Right. There
So
were
there-
several different items of clothing and lots of other things that were consistent from one to the other among them. That's the one that sticks out in my mind, as showed up in every video.
I believe, I actually don't know if it was in every video. I don't know
Okay.
if it was in the Family Dollar video.
May have just been testified to. Okay.
And I
thank you.
don't, that's the only one that I don't know about the Family Dollar. I do know it was consistent in the other 4. There were other pieces of clothing, though, that were consistent in 1 or 2 of the robberies, and then other pieces of clothing that were then consistent in separate robberies. And when you put them all together, you connect all 5.
Yeah.
You also have the blood of one of the victims from Missouri on the shoes that are recovered, and then the wearer DNA also being of Deron King inside his house. You also have, and this is extremely important, you have the products, the ill-gotten gains of the robberies, the liquor bottles, you have the coin wrappers, you have gray plastic bags that are consistent with the gray plastic bags that they were emptying the cash into, are recovered at the house, and so is just a pile of discorded currency. So yes, while the statement is an error, it would have virtually no impact on the jury, particularly when you take into account this was a 10-day trial. There are over 1,800 pages of records. A single statement made by the prosecutor would not stand out to the jury compared to the other evidence that was presented. So I think it is, I am absolutely safe in saying that there is no reason to believe that it had any impact on the jury's verdict in this case.
Would you make the distinction that we discussed with your opposing counsel, that we know might be okay if the evidence is undisputed, but it's problematic whenever you have a situation where the evidence is still ambiguous or subject to competing interpretation.
And that is the case law. So if it is something that's uncontroverted, you can say we know. For instance, I mean, the classic example, I guess, would be if both parties say that they were there, if a defendant were to say that they were there and we say we know the defendant was there, it's uncontroverted, so it's not an error. And I agree in this statement, the one that is most controversial is that we know the gloves were there. I think it is very easy to believe for a jury to have read in the correct reading, which is that it's consistent, and make the decision for themselves. I also think that when combined with all of the other evidence, that it's not that the gloves are consistent or that the gloves are a major factor. It's that this one statement about the gloves would not have stood out to the jury in any significant way, considering the length of the trial and the amount of evidence that they had seen. So I'm very comfortable saying that this should not be reversible error. I am comfortable that it was error, though. In that one instance, I do not believe any of the I submit or we submits are problematic. I believe a lot of the other I thinks are not. If you look at the context, it is saying like, looking at the evidence as a whole, I think you will find that rather than.
Sometimes people say, I think, to soften a statement too. And sometimes they go, I think, don't they? So we don't know that
Right.
here. I mean, in a 10-day trial, it's possible that a human prosecutor might not remember every single thing that happened exactly as it happened and might soften a statement with, I think, in that tone, isn't it?
I mean, it would be possible. I don't know if that's what happened here.
Okay, we can't know. That's my point.
Correct. I think you can look at the context, though, to see what it was being used as. If it's being used simply as a soft, I don't know what the evidence shows, or more of a, similar to saying I submit to you.
Assertion of opinion. That's what you're trying to avoid, right?
Correct.
Okay.
And what about the 2 times that the prosecutor said, I believe?
And I think I covered these. I think it's clear from the context of the entire statement, what the prosecutor was saying was that look back at the evidence and look at what we've submitted to you, and I believe it's a case that you can sustain a verdict on, which I think is an appropriate way for her to phrase that. I believe it's kind of the natural way we would talk about the evidence, and I don't think in this case, from the context, it's similar to the cases that the defense cites. Typically when I believe gets in trouble is when the prosecutor is making a definitive statement about credibility.
Yeah, there's a big difference between saying, I believe the defendant's guilty, and saying, I believe that when you look at the evidence, you will conclude.
Correct. Or saying, I believe this witness's story, which is also error, to vouch for the credibility. I don't think in this case any of the I believes are ever in reference to vouching for a defendant's or for a witness's credibility, or to vouching for the final determination of guilt or innocence, which are the 2 contexts in which this court and pretty much every court finds that it is error to say I believe. Final determinations of evidence, weight and credibility to be given to particular pieces of evidence, or weight and credibility of witnesses' statements. If there are no other questions about the prosecutorial error, I'd like to address the antagonistic defenses issue that was claimed. Obviously, the state's first position is that, I'm sorry. Obviously, the state's first position would be that this is in no way preserved for appeal. I particularly find problematic that the defense waited until the verdict had been returned to raise a question. I know this court has addressed before whether a defense attorney is required to object during closing arguments, specifically because the logic has been that objecting during closing argument may draw more attention to a problematic statement. That's in the context of prosecutorial statements. I think in this case, though, you still have a problem that at the end of the closing argument, when the jury is excused, the defense neither defendant jumps up and says, that statement was an error, these should have been severed, we demand severance now, we demand a mistrial now. There was a strategic decision on the part of the defendant to ride out the evidence that had been presented as it was and wait for a jury verdict. And at the point where you are waiting for a jury verdict, when you have had ample time to ask for a mistrial based on those statements before the verdict, you are trying to get 2 bites at the apple. You are trying to say, we're going to wait and see if we might get an acquittal, and then we're going to bring it back up on appeal and see if we can get a reversal based on that. And that is absolutely inequitable. It should not be allowed. Even if you give the defendant the benefit of the doubt that they did not want to raise attention in front of the jury, there was ample opportunity once the jury was excused to raise this objection, and it never was.
And if they had raised it before, would you be arguing, well, they haven't shown that it was prejudicial?
Yes, and
That the verdict would have been the same.
Right.
And so the defense, has to be in a position that it was prejudicial because I was convicted,
correct.
you know?
Well, I mean, if they had raised it before, if they had raised the issue for a mistrial, I think what you would get down to is a weight of how much you would get to the argument. The judge would have to make a determination. Was the damage done at trial in the closing argument sufficient to warrant a mistrial? Can it be mitigated by instruction? And we don't even get there. The district court is never even given an opportunity to give any sort of mitigating or limiting instruction to the jury based on the statements. There's no way to mitigate the damage without an objection, which is one of the reasons in equity parties are required to make objections, is because there is some trial error that can be mitigated with instruction, but here there was no request for a limiting instruction, for a mistrial, for anything. The first time there was an objection raised was after the verdict at the motion for new trial.
And remind me, did both defendants get convicted of exactly the same crimes?
I believe so.
So it didn't work either. The betrayal didn't work.
No, it did not. It did not, at least to the attempted capital murder. Because I wasn't prepping Cecil Megerson's, I didn't look at his journal entry. I know the only count that Deron King was acquitted of was the robbery of one of the victims, and it had more to do with the fact the victim said he wasn't sure if they even took the object that he had thrown
Right.
from him.
Cell phone from Jones in the one store.
I believe
I
so.
think that was the one he got acquitted on.
And I think that had more to do with not even knowing if the object was taken. I don't know if Cecil Megerson was convicted of all counts. I know he was convicted of the attempted capital murder. I do think in this case, even if the court were to look at the antagonistic defense and the prejudice to the defendant, it's important to note that I believe defense counsel has mischaracterized some of the statements that the trial counsel, James Spies, made at the time. He did not ever instruct the jury to find Deron King guilty. What he said is that both the jury can weigh the evidence independently for both defendants, which is a correct statement of the law. It's in fact what the jury was instructed on, and that they can make a determination independently on both defendants. I will concede that it was quite a strong statement, but it never went as far as saying, find Deron King guilty. There was no point at which he was ever saying, you should find Deron King guilty and my client not guilty. It was more, you can find him guilty and still find my client not guilty, which is a correct interpretation of the law. It's a correct recitation of what the jury was instructed. Furthermore, I think you still get down to the argument, even if there's some prejudice, the evidence against Deron King was overwhelming in this case. And what I'd forgotten to mention earlier is twice in the jail, he told deputies, I shot your friend. And the jury heard this. And that is incredibly strong evidence. He was bragging about this. He seemed to be quite proud of the fact that he had shot a law enforcement officer. So the jury had a mountain of evidence to use to convict Deron King. And neither of these potential errors, either the one prosecutorial statement nor the possibility that an antagonistic defense was presented, denied him the right to a fair trial or in any way would have impacted the jury finding him guilty. And the state believes that argument carries over both to the sufficiency of the evidence argument and to the cumulative error argument. I would ask that you affirm the convictions and deny that he's good.
Before you sit down, do you want to address your opponent's late blooming request for a Van Cleve remand?
I don't think it's appropriate in this case. If the defendant would like a collateral appeal, it can be brought as a collateral 1507. And
it's not appropriate in this case because it wasn't asked for before now or for
correct.
some other reason?
Correct. It's never been asked for. It's never been before the district court, so it would be a completely original claim while
Well,
it is.
that's the point of a Van Cleve remand, is it's not been before the district court, so we give the district court a crack at it without the extra proceeding of a 1507. Do you have any substantive arguments other than the procedural, gosh, it's late blooming?
Not really.
Earlier you
I don't
mentioned you
know-
thought
I
it
don't
looked
know.
strategic.
Correct.
Earlier you mentioned you thought it looked strategic.
I do think it was strategic, the decision not to ask for a mistrial or.
But that's something that would be addressed by such a remand, right?
Correct.
Okay, thanks.
Any more questions? Thank you, counsel.
One moment, Your Honor.
Certainly.
The one thing I would say is that counsel just mentioned that my client had made some statements in the jail about shooting the officer or whatever. My client was actually charged with criminal threat, and that's one of the counts that went to the jury, and the jury found him not guilty of that count. Whether the alleged inculpatory evidence is something the jury didn't believe or what, we don't know, but we know that he was not convicted of that count. They were both, it was two officers, two deputies who made those statements, and they were two different statements. They weren't together. They didn't see him. They heard him say them over, I don't know if it was over the microphone or whatever, or at least that's what they said, and no one else substantiated it, and the jury didn't believe it. Other than that, unless you have any questions, I would just stand on my brief.
I have one quick question on the Van Cleve issue. Counsel, have you done any independent investigation of this case outside just looking at the record?
I looked and I didn't find anything on it, Your Honors. I would just admit that if you don't take care of it here, it's going to come up again, and that's not a threat or anything. I just know that Mr. King's going to raise the issue on 1507.
All right, any more questions? Thank you, counsel.
Thank you all.
We thank you both for your arguments this morning. Clerk will take this matter under advisement.